Number 3. Your Lordship, in issue number 3 is stated whether the burden of proof of legal insanity on the burden of the defense is in part with the burden of proof on the appellant. Your Lordship, I am referring to paragraph 15 from page number 7. In insanity cases, Your Lordship, the burden of proof lies on the defense but with distinct standards. Your Lordship, the appellant bears the burden of proving the respondent's guilt beyond a reasonable doubt. Your Lordship, a stringent standard that requires a high degree of certainty. In contrast, the defense burden of proving in establishing insanity is typically clear and convincing evidence that is more likely true. Your Lordship, from paragraph 16, their Lordships of Supreme Court have also considered the plea of insanity under section 84 of IPC in the case of Bihari versus state of Uttar Pradesh. They say that the state of mind of a person can ordinarily be inferred from circumstances. Thus, if a person deliberately strikes another with a deadly weapon, which according to the common experience of a mankind is likely to cause an injury, as we have seen in our case, Your Lordship, and sometimes even a fatal injury depending upon the quality of the weapon, which is the weapon was a 7-inch, Your Lordship, and part of the body on which it is struck. Your Lordship, it will be reasonable to infer that what the accused did was accompanied by the intention to cause a kind of injury and which in fact resulted from that. Your Lordship, now it is not for the appellant to establish that a person who strikes another with a deadly weapon was incapable of knowing the nature of the act. Your Lordship, whatever he was doing was either wrong or contrary to law. It is obvious from his behavior that it was contrary to law. Your Lordship, everyone is presumed to know that the natural consequences of his act. Similarly, Your Lordship, everyone is also presumed to know that these facts that the appellant has to establish, everyone is presumed to know the law. Your Lordship, referring to paragraph number 16 from page 8, the Honorable Supreme Court in Dahiabad Jhaganbhai Thakar versus State of Gujarat have held that when a plea of legal insanity is set up, the court has to consider whether at the time of commission of the offence, the accused, by reason of unsoundness of mind, was incapable of knowing the nature of the act, or that he was doing was what was either wrong or contrary to law. Your Lordship, furthermore, under section 6 of BNS, it is stated any fact is relevant which shows or constitutes a motive or preparation for any act of issue or relevant fact. Your Lordship, it is humbly submitted that the general burden of proof lies on the appellant and honest stated, and thus the witness Gabriel, their neighbor, with his own eyes saw that Ruby was lying on the floor, fatally being injured and with blood, and he also delivered in his statement, Your Lordship, that he saw Robert with the axe. He also saw that Robert was concealing the axe, which had his fingerprints imprinted on the axe, Your Lordship. Your Lordship, moreover, the appellant proved the allegation that in her declaration, while she was writing her death declaration, she has also proved that, Your Lordship, it was Robert, it was her husband who has hit her with that object, Your Lordship, and beyond reasonable doubt she has proved. Thus, the burden of proof that lies on the appellant and was thus proved beyond reasonable doubt, which is a relevant fact. If Your Lordship is satisfied with issue number 3, the counsel seeks permission to proceed to issue number 4. Much obliged, Your Lordship. Your Lordship, the issue number 4 states whether the dying declaration and witness can be the basis of murder for conviction. Your Lordship, referring to paragraph number 21 from page 9, I would like to say a dying declaration is a statement made by a person while they are dying. Our client Ruby, she made this statement while she was dying. This is a dying declaration, Your Lordship. Your Lordship, from paragraph 22, I would like to read out the following core principles have been laid down by the Honorable Apex Court in the case of Agrument versus government. Your Lordship, there are 3 conditions that states that dying declaration can be the sole basis of conviction if it inspires the full confidence of the court. Your Lordship, the second states the court should be satisfied with the deceased was a fit state of mind, and as stated by her doctor, that is witness, that our client Ruby was in a fit state of mind by delivering her dying statement. Your Lordship, the third one states that whether the court is satisfied that the declaration is true and voluntary, it can base its conviction without any further corroboration. Your Lordship, Indian courts have consistently held that a dying declaration can be the sole basis for conviction. Lastly, Your Lordship, in the case of Ushanani versus State of Punjab and Chittor versus State of Rajasthan, it is clearly stated that the absence of a motive does not necessarily undermine the declaration's validity. Now, if our respondent comes with the intention that their client was not in the intention of killing his wife, in the case it is already stated that, Your Lordship, Ushanani versus State of Punjab and Chittor versus State of Rajasthan is clearly stated the absence of motive does not necessarily undermine the declaration's validity, as the nature of the crime itself does not require proof of motive. Your Lordship, a dying declaration is an important part of evidence and also the basis of conviction. Your Lordship, the appellant on her deathbed itself stated and made the dying declaration when she was in a sound mind. Moreover, she stated it was her husband, it was her life partner, Your Lordship, who has hit her with that axe, and which corroborated with the crime scene and also from the witness of Gabriel's statement. If Your Lordship was satisfied with issue number 3 and 4, the counsel seeks permission to proceed with issue number with prayer. Much obliged, Your Lordship. Your Lordship, therefore, it is briefed in the light of issues raised, arguments advanced and authorities cited that this Honorable Supreme Court may be pleased to adjudge and declare that the petition under 136 is maintainable in the court of law, that the petitioner should be granted justice and accused should be punished under the provisions of the BNS, that the plea for insanity must not be accepted and the accused must be punished with the charges of murder and or past